Good afternoon. Welcome to the Berkowitz and Hanna Love in the Law podcast. My name is Russ Berkowitz, senior partner of Berkowitz and Hanna. Today, I am pleased to have my partner, Christina Hanna, be part of this podcast and share with us some information regarding a couple of cases that she's recently resolved. Just to hear a little bit more about Christina. Christina, while she's a named partner, she started with the firm actually 20 years ago, the summer before she passed the bar exam. And now heads up, after all that time, the personal injury section of our practice. A lot has happened in Christina's life over the last 20 years. She got married, she had 2 children, and I'm very proud to have been a witness to Christina's journey. A tireless worker, Christina started with us, as I said, as an associate back in the early 2000s, and over the years, she's perfected her craft by handling thousands of personal injury cases of all types and sizes, and has flourished. One thing about Christina that I've always respected is that she never is afraid to take on tough cases. On more than one occasion, she's taken on a case that may have raised an eyebrow of mine, thinking that why is she taking this case? But her and her team surprised me with great results on these cases, despite the complicated issues and the chance of a risky outcome. So without further ado, Christina and I are going to talk about 2 cases specifically that she recently resolved, and I hope you enjoy the podcast.
Hi, thank you, Russ, for the history of our working together, and 20 years plus seems like it's gone by in the blink of an eye, but happy to be here on the podcast as well. And thank you again.
Glad you could be here. We have some ground to cover today. So I think what I'm going to do is let's talk a little bit about your practice. I mentioned earlier in the podcast that you take all different kinds of personal injury cases, small cases, medium-sized cases, larger cases. Many of the cases involved either car accidents, fall downs, and dog bite cases, and a variety of other personal injury cases where people have been injured because they believe as a result of the negligence of another party or a business. And why don't you just explain to us, just so we understand your background a little bit, how did you get involved in doing these kinds of cases? I mean, I mentioned you worked here at the firm as your first and only job, but what led you to want to do this kind of work?
Right, absolutely. So I really became interested in plaintiff's work just by virtue of, experiences throughout, growing up my life and in college and law school, realizing that it's important to, communicate with other people, help other people who are going through challenging and difficult times, and especially just being an advocate for people who have been through, negligence. Unfortunately, they've lost a family member through the negligence of another party or entity, and just realizing that we could add value to that experience and we can guide them through the legal landscape and try to seek that fair, just, and reasonable compensation. And, we're fortunate to have had a variety of clientele throughout the decades that we've been working together, Russ. And I know that we have really skilled and supportive paralegals and legal support staff that assist our clients and us on a daily basis. And I always tell people who contact us in terms of, a potential case that, this is not just a case. This is your life or your loved one's life. Something here has to be brought to the forefront, that you're just not another file in our eyes. And the insurance and the defendants on the other side may sometimes, look at these cases as just a case. But we're able to spot the legal issues when potential clients contact us. That's our job, really, to hone in on the facts of each person's situation. What has happened, what's currently happening in their lives, or, what might happen in the future. So we take this approach and a philosophy rather, that all are welcome. People are contacting us because they believe something has happened. Maybe something is just wrong, or there has been negligence or recklessness. Whether it's a construction case, a drunk driving case, pedestrian struck by a vehicle or a bicyclist struck by a vehicle, um, an auto accident case as well, or perhaps your child was injured at, a camp or at school. So we're fortunate where we have had such a variety of legal issues to work on. Each client, or the cases where someone has passed away, there's a story, and we're here to listen, here to learn about the facts and the stories of our clients and people who've passed on, and develop the case. And it's a process. Sadly, the cases are often very challenging, to work on, in terms of, the loss of life, the loss of enjoyment of activities, loss of limbs in some cases, just devastating fact patterns. But we are well-versed in the law, well-versed in the cases that have developed through the decades. We are working on these cases for clients, cases and laws that are still developing and evolving. So we're able to advocate for those clients in the legal realm.
One of the things that I've noticed over the last 20 years, and it's been rewarding for me, is the fact of how your growth has taken place as an attorney. Obviously, when you came to us in the summer of the year that you were hoping to pass the bar exam after your law school career, you didn't know a heck of a lot. And now I fast forward 20 years, and you're sort of a go-to when it comes to personal injury cases. When you look back over the last 20 years, what's the difference for you in terms of how Christina Hanna has grown as an attorney?
Sure. I have to say, right, exactly. When I first started in this field, there was a lot of on-the-job training and that practical side. And sure, I took classes in law school about representing clients and just, certain areas of the law, but there's nothing better than an on-the-job practical experience. And I know that when we first started working together, you were a very, very instrumental piece of my learning in my career, and still are. And I know that you're a mentor to not only myself, but others here in the office as well, in terms of, sharing that experience and knowledge and the collaboration that takes place in the firm on a daily basis. And I can say that from the beginning until now, I think it's important for anyone in any field to look back, take away the highs and the lows. What have you learned? What could be done in a different way? Or, how do you learn from those experiences and really apply it to your practice today and going forward? I think as lawyers, we're constantly evolving. We constantly have to be up to speed with the laws, the recent court decisions, rulings, arguments we make in court before numerous judges throughout the state, state bar, federal bar, and just using our skills as advocates, to do our best for every single client and family for whom we represent.
An experience matters, right? I mean, the experience that we had when we were both first-year lawyers is much different than the experience that we have today. And I think that, at least from my perspective, it's important to always stay humble, because there's always something out there that we don't know. Even though we've handled almost every different kind of case, whether it be a personal injury case that you work on or a medical malpractice case that I work on, there's always a learning experience that happens from every case that we have that make you a better lawyer. And that's why when I was saying it's rewarding watching you, there's so many different kinds of cases that we've got in this office. I know that we'll specifically talk about 2 cases today, but we've had some crazy cases over the years. And looking back, I mean, those were learning experiences because they had unique fact patterns that threw us with some challenges on how we could recover for a client in those cases. And I think that unless you go through the experience that you've gone through, you may not have been able to handle it in the same way your first year or second year or third year as you would in your 15th year through your 20th year. Think that's a fair statement?
I think it's more than fair. I think it's spot on. We always talk about no two cases are exactly the same. Sure, you might have seen a similar fact pattern. You might know the players involved on the other side, or you might recognize the defendant on the other side. But you get to know the nuances of every case. You get to know which laws will apply. But also, I think it's a great point you raised that we're experienced enough to know what to do to take a case on for a client and run with it, work it up, do our investigation and due diligence, but also stay with that client and the fact pattern throughout the life of the case. And things evolve, right? How many times have we had cases where we wouldn't believe this happened, or this witness came forward, and now we have a little bit of a different landscape, or an expert gets involved on either side, and the landscape is changing and evolving. So I think it comes back to what we were talking about earlier too, just being, flexible, being tenacious. Okay, what are we doing now with the circumstances in a case? Or are we creating different circumstances by application of a new set of facts? Or, I think it's just always important to have that perspective, right? What is our client's case about? What are the laws that apply? And, oftentimes through depositions and discovery and just the nature of the case itself and the process, things evolve. But usually towards that end of, okay, we're ready to engage in a meaningful settlement conversation or a pretrial conference.
Right. I mean, times change, and the way these cases evolve change, and we have to adjust with the times. But looking at, as I mentioned earlier in the podcast, the cases that we're going to talk about today, one of the cases that you handled and you resolved with a 7-figure result is a man who was working in a building here in, I think it was in Stanford, and he went up to the roof with another man, and he fell over a broom handle, which seems like such a theoretically klutzy thing to happen. But we got the case referred to, and he hurt himself pretty badly. He had a head injury, he had a spinal injury. And of course, the challenge of that case, which you'll talk about in a second, is the fact that, as I said, he went up on the roof. There was a broom handle. He didn't see it. His foot went on it. The broom handle went flying, and so did he. And the rest was history with his injury. And so we got the case referred by a New York attorney to us. The client was from New York. And I passed the case off to you because I know you like these tough cases, which I thought was, going into this case, was a tough case. Tell me what your thoughts, so just so the audience understands, when we get a case in, and whether it's generated through directly from you or referral from another lawyer in the office to you to handle when it's a personal injury case, what's the first thing that you do when you get the case referred to you and you just generally know what the facts are regarding that case, as this one?
Sure. Right. It's a great example, great outcome, and a really challenging case in many ways. But essentially, from day one, we talk to the client. We're getting all of the facts as much as we can at that time, and just building up, the storyline, really what happened, what transpired there, the scene of that incident. And those are the premises liability or construction cases. And usually there's a lot of entities and contractors and subcontractors involved, and you have OSHA to look at as well. So part of the investigation from day one is really, again, spotting those issues and, getting the facts in order, and just learning from your client also what their goals are too as well. And, it's a collaborative process as well in the beginning, and within the office, I have great support staff to help piece everything together. But, we're not afraid to investigate and take on cases that other firms, will not and may pass on. We're up for the challenge. And, there's no guarantee in any case anyone takes on, but there's a guarantee that we will work and do our best. We're all in. And I think our clients can sense that from the beginning, and they know it all the way during the life of the case as well. We make sure they do. And, again, those liability cases are so challenging in that, usually the benefit of an expert witness is tremendous. We're dealing with experts at OSHA, engineers, safety experts, medical experts as well. And unfortunately, in those cases, the damages or the, physical and emotional and the non-economic damages are usually substantial.
Why are those cases so challenging?
Yeah, I think for a number of reasons. Usually, we are working with corporations or entities on the quote unquote other side who are always not always willing to view the case through the same lens we are in terms of liability. Maybe there's an aversion to accepting, or acknowledging that something happened here that was negligent. And there's usually a lot of pushback in these cases, or it comes down to sometimes, witnesses on the scene, who can testify about what was going on a job site, for example, or who left a broom handle there on an active work site and why. And I think that there are so many facts in every case that, lend themselves to, legal issues that, notice, for example, right? In these cases, there's a rule in Connecticut, we have to prove, actual or constructive notice of a defective or hazardous condition. So again, it's very fact specific, and sometimes there is that pushback, and parties may not be willing to engage in negotiations or take a no pay position, if you will.
And I haven't done those kind of cases in a long time, but I do remember that if a client came into my office and they had 5 prior falls and they'd been to 5 different doctors and made 5 different claims, that those aren't the kinds of clients that if you're, if they have a serious injury, that you may not want to take that case because credibility, as you mentioned, it gets in the way sometimes because this person who's predisposed to falling maybe would have fallen without anything being defective. But on the other hand, as in this case, our client was a pretty credible guy. He was a hardworking guy. He was in the business, if I remember, for like 25, 30 years. Did not have a big history of prior injuries. Nice person. Those are all, I would think that those are all things that you consider. You must have your own, I don't want to say a checklist, but in your head, there are questions that you probably ask to the client because you want to know everything that you can about that client, because certainly the other side's going to dig into their history to find it out. It's better that you know about it up front in how you handle this situation, correct?
Right. Fair, exactly. And, it's important, to know your client. And, some people may feel reluctant to share, about a prior injury, or there's multiple prior injuries involved. And there might be that level of, gosh, what if they don't take my case? Or what if they think of me or look at me differently? And maybe my case isn't as strong, but, we're fortunate to have a lot of clientele and even, friends or family of past and current clients who are coming back for an incident that occurred. And again, they're coming to us because they've been harmed, or there's a fatality, or, again, something traumatic, something has happened in their lives. And they come in and again, we say, tell us your story. What happened? How are you doing? What are your goals here? What are you, what are we here to fight for together? And also, guiding them through the process. But yeah, sure. We have a lot of questions we ask in the beginning. We also tell our clients that they know they can come to us if they have any questions. We welcome that. Communication is key, right? Tell us what's going on in your life throughout the life of the case, but also, we don't turn those cases away just because there might be a history of priors. I think that, a lot of people are in the situation where it's wrong place, wrong time, but in Connecticut, luckily, we have that maxim that you take your plaintiff or your claimant as you find him or her, and pre-existing conditions can be aggravated by a current incident, so our law is pretty liberal in that regard, and thankfully, so all is not lost, and we encourage the clients, just to be communicative with us and facts they might say are not important, talk to us. Let us help decide if it is important or how that fact might not be a negative.
And I'm assuming that in this specific case, based on the fact that you had a great client, you had great experts, they had you as their lawyer, the other side approached you at some point before the trial date and said, hey, Christina, why don't we see if this is a case that we can try to resolve through mediation? And maybe you can explain to the audience who the players are at a mediation and how do you go about picking a mediator?
Right. So I know we've mediated, you and I, and hundreds of cases throughout the last decades, and we still are actively mediating or even arbitrating them. But it seems that in a case such as this, the complex construction, that it's beneficial for the parties to usually present the case to a neutral attorney or a retired judge. And in our state, we have a really great pool of retired judges and attorneys who are well-versed in these types of construction cases and medical malpractice cases, of course, and our car accident cases. So we have to have that level of comfort to recommend it to the client. And the other side has to also agree to submit the case to mediation. So there's this agreement generally after conversations between the lawyers and the lawyers' respective clients to get to the point of, let's submit the case for mediation. Let's do this either in person or in a virtual context. And it's a nice way, again, for everyone to be heard. Raise the issues together, and the mediator will, be the facilitator of these conversations between the parties involved. And it can be a long session at times. It could be a mediation may last over several sessions or several days. We've both had cases where the mediation you may make good progress at one session and then come back for a continued session, or even just conversations after the fact to keep the dialogue going. So mediation is a nice, cost-effective way for the parties to come together and have a neutral assess, the issues or maybe just the value. Can we come together and bridge the gap? Of course, trial is always an option. So if a mediation isn't successful, and sometimes it's not successful for a number of reasons, continued discussions, communication is really important. How many times do people want to walk away and close the door and say, that's it? On either side, we're going to trial, see you in court. I think that our clients know that, there will be options that develop over time, and we like to create those options as much as we can and be in the driver's seat, so to speak. But, the court's always there with the clerk's judicial resources for those trials that will take place if there's still a disagreement over liability or damages and the overall value.
And there's a little bit more certainty. I mean, sometimes you have to try a case. If the other side offers zero and you want $2 million, that's a case that's going to trial. But most cases in this day and age aren't really like that, because why would you take a case where someone's going to offer zero, which means they think that your case is terrible from a liability standpoint? So the mediation many times becomes a substitute for the trial, and it gives the client the closure knowing that they've gotten their day. They may not have gotten their day in court, but their day in court may not always look right after the verdict comes out from a jury. There's nothing worse than, let's say, being offered $500,000 on a case, and you're looking for $3 million, and the jury comes back with zero, and it turns out you probably could have settled the case at a mediation for $1 million. And it all depends, I guess, on the case. It's not really, there's no hard and fast rule, but nowadays the unpredictability of a jury. I know the public only sees the big wins that show up in a local newspaper or online, and they think that people are getting millions and millions of dollars every time they go to court. They don't hear about all of the losses that take place that actually creates the risk that we share with the client, so that they have an educated decision that they can make about whether they want to try the case or whether they want to resolve the case either through your phone call or negotiating with an insurance company over the phone, or whether you want to resolve it at a mediation. So there's a lot of, as you said, there's a lot of moving pieces that, and as the lawyer, it goes back to that experience level that you have that you may not have had 20 years ago, but going through this, all these different processes, it makes a huge difference that they have someone like you who's won cases in court, lost cases in court, and has done exceptionally well at mediations. And I think that you really you're a credit for your client. It's good that they have you because you're always looking out for them. And I've never seen over the years an unhappy client that's walked out of here when you're their lawyer. And I think it's commendable on your part. But I think that it makes a difference that when other people look back years later, they're not saying to themselves, darn, I should have tried that case. I shouldn't have listened to that lawyer. I don't think that happens with you. I think that you lay it all out there for them. You make them you let them understand what it's all going to be and what the risks are, and you let them make the call. And most of the time they listen to your advice and it works out really well. We don't have much time left, but I do want to just quickly change gears. There's that second case, which we can't talk about how much you actually received because you settled it on what's called on a confidential basis within the settlement documents. But I found it to be a fascinating case. So I just wanted you to quickly talk about it. I mentioned during the intro that it involved a man who was 101 years old. Now, it's another case where they came to me, because it was a personal injury case, I turned them over to you. And tell everybody, what was your first thought when you heard that a man who was 101 years old fell out of a window and you were being asked to sue an entity for what happened to him in the fall?
Right. I remember it well because it was a fact pattern where I think we did a double take. Like, wait a moment, what happened? And how old was this person? Because it's so rare that, you hear about this type of tragic outcome, really, and what was interesting about this was, right, the family had known you and, trusted this case to you and, worked together on that in the beginning just to, again, piece this fact pattern together. And also who was this, the person who passed away. And, at that point, we really weren't looking so much through the lens of the age, but in Connecticut, there's a wrongful death statute. So we look at, obviously, a number of factors. We look at what occurred. We look at the injuries. In this case, it was a fatality. So there was very limited, pain and suffering before the passing, the untimely passing. And also, again, you look at the life expectancy of your client and, what's the analysis under the law, but it's not your typical fact pattern. And that's what made it all the more compelling for us, to jump in and say, look, this is somebody's loved one. And tell me the story about, your father. Tell me what happened about your uncle. Tell me what happened. And what type of life did they lead? Who were they? Add some more color and context to what occurred and what could have been prevented. And I think based on the principle of what had occurred, that we all felt strongly that, we're going to be all in. We don't know what may happen 5 months from now, a couple of years from now, but we have enough now to work on the case and find those, experts, and develop the case through depositions. And it's such a horrific outcome. But what was even more compelling about this was that this is not the first time that an incident had occurred in a similar setting. And I think that helped us realize that there's more going on here at, the facility and who are the players involved in this, repeat incident. So I think, again, from a principle standpoint, seeking that justice for the family so that the same thing doesn't happen to another unsuspecting person in the future.
how tricky was it that that the client was 101 years old when you stack him up against, most of our clients are much younger than him. And a lot of them have what's called a loss of earning capacity because at the time that they passed away, they had a job or they were recently retired and they had a family that, they had their kids and they had their grandkids and they had hobbies. And in this case, you had a gentleman who was living in an assisted living place and he had a nurse taking care of him. And it gets a little tricky in terms of, I would think, putting a value on that case. And so, putting aside this case, when you get an elderly person, how do you like to be able to project to, whether it be a jury or the insurance companies, that this person's life had meaning, that this should not have happened, and because the standard in Connecticut is not necessarily to punish the defendant, but to compensate the plaintiff for what they call as fair, just, and reasonable compensation for their injuries for a wrongful death case. But how do you project that to get them feeling like they have a risky proposition in trying this case against you?
Right. No, so really good points there. And I think that, and good discussion that, we look at who is our client, or who is the deceased, and what type of life have they lived, and who were they in relation to other people in the community, and maybe an assisted living, community as well. There's friends, there's family, there's visitors, there's, your doctor, there's people at the local store and pharmacy. So I think that we look at the whole context of our client and who were they before the incident? Who are they at the time of the incident? And if there's a fatality, of course, then we know that their life has been tragically cut short and come to an unlikely end. But in the cases where our clients, have survived a terrible incident, or, maybe a traumatic amputation of a body part or multiple body parts, we know that we know how they were living and who their community was before the incident. We know what happened on the date. We certainly know, how their lives have been affected after. And, in that case, we can look at the life expectancy and, the statistical figures and tables that will help us argue and guide us in terms of, future cost of care, or, in cases where we have an economist come in and opine as an expert with, opinions on, future cost of care. And the goal is to help the client out in terms of how do you value this case in terms of, present day value based on what might happen in the future, based on your medical conditions or your medical situation and those expert opinions in the present time. So, in the cases where our clients are elderly, again, I don't really look at each client through that lens of, 80-year-old client, you far surpass your life expectancy. I look at it in terms of, what are you doing now that you can't do before? How is your daily activities of living? How have they been affected? What is it like? And we often have that conversation really candidly with clients about, hey, how are you doing? Did you take that trip you were going to go on? You had that planned, or, I had to miss my granddaughter's recital. I just can't do it, or I just can't drive anymore. And, that's that day-to-day, that level of pain and suffering where, we feel passionate about fighting for that. And the question is always, how do you value a life? Or how do you value, a child who's born and doesn't survive due to a negligence case, a labor and delivery case? How do you value or quantify what could have been, or what type of life that young person would have led, and all those experiences that come with it, all those intangibles. So it's very hard, like from a legal perspective and a philosophical perspective, to put a monetary value or even try to quantify. But, like you said, we have the concept of what is fair, just, and reasonable.
I took a peek at your mediation statement before you sent that out to the mediator in that case, and I thought it was powerful evidence that you are going to present to the mediator, that 20 seconds or so after that the client fell out of the window until he hit the ground must have been the scariest 20 seconds of his life. And the fear of imminent death, I can't think of anything scarier, actually knowing that the end is going to be in the next 5 seconds. And I think that was powerful stuff, and that probably made a difference in you resolving the case. And I commend you for that. And there was another job well done by you and your team.
Thank you. It was a really important case for us to work on, and I know you were involved as well throughout the life of the case, and I think that what's also important is what we do with the offices will often have a focus group or roundtable these cases just to get a sampling of what people's reactions are to this, and how can we do our best job to achieve that result that will satisfy our client and know that we did right here. We tried to hold people accountable and bring the case to a natural end, and make sure that there's some validation, right? The story's been heard, it was told, people listened, and here's an outcome that will help bring closure to families who need it. And some may not realize that it's needed at that time, but there's a benefit there.
Well, Christina, I know how busy you are. Like all good things, this one has to come to an end, and I appreciate the conversation today. I hope the audience enjoyed learning a little bit about you, the cases that you handle, how you approach these cases, and the passion that you have for the clients. And I expect the next 20 years of your career will hopefully be just as successful as the last 20 years, and you're a credit to the profession. And it's been a pleasure sitting with you today and hearing just a snapshot of what goes on in the professional life of Christina Hanna. I mean, a lot of people don't know. As I said, Christina's married, has 2 kids, very active in her church. She's on the board of directors of a nonprofit. She has a very, very busy life, and is leading a life that she should be very proud of. So thanks for your time today, and I will see you soon.
Thank you for the conversation. I'll definitely be seeing you soon.
All right. Thank you.